Welcome to Trust and Estate Clarity with Dada Law Office.
Welcome to Trust and Estate Clarity with Dada Law Office with Attorney Codi Dada, founder of the Codi M Dada Law Offices in Nevada, recognized as one of the top 10 best law firms in California. Codi focuses exclusively on estate planning, trust, and probate administration. I'm Shameika Rhymes, and today we're cutting through the legal jargon to help you protect your assets, avoid the headaches of probate, and leave a lasting legacy for your family. Codi, thank you for being here.
Thank you, Shameika. Nice to be here.
Well, Codi, many people in the North Bay hear the word probate and know it's something they want to avoid, but they might not realize just how much the experience varies depending on where they live, which brings me to my first question. What actually happens in California when someone dies without a will or any other estate planning tools in place?
Great question. So that's called intestate, okay? And what that means is that your loved ones or someone representing the estate has to go to probate court and file a series of documents to become appointed as the administrator of the estate. That means that they obtain a court order called letters of administration that gives them the authority to manage your assets and pay your bills and settle your estate and ultimately distribute it according to the instructions of the probate code. And the first process is getting appointed as the administrator. So they have to file a petition, and then it requires putting a newspaper ads called publication to give notice to the world if anyone is owed money to your estate or has any claim against the estate. It's a legal way of giving notice to the world. And then they have to give notice to all your legal heirs. That means all your closest relatives. Your legal heirs are defined from the probate code. And then they have to file a proof of service with the court showing that they have, number one, put the newspaper ad in and mailed the notice to all your legal heirs. If everything is completed, satisfactory to the court's expectations, then they will issue a court order called letters of administration. Now that is just the starting point. The next step is gathering or marshaling the assets of the estate. That means that your administrator has to identify all the assets and create an inventory list. Once they have the inventory list, they have to file an inventory and appraisal and send it to the probate referee, which is the person appointed by the court that would give us the date of death value of all the assets in the estate. Now, this process gets complicated because it has to be filled out in an exact manner, and it has to list every stock, every individual security that you own in a certain manner. And then the probate referee has up to 30 days to provide a date of death value. And then the probate referee gets paid a percentage of your estate value on top of the executor fees, what's called the statutory compensation. The probate referee gets paid. Once the inventory is completed, the administrator is required to settle all the bills and settle all taxes and all financial obligations. And once everything is settled, then we file what's called a final petition for distribution. And that's the document that tells the court that you have done everything you're supposed to do and that you're ready to distribute the assets. If you don't have a will, then the law tells us how to distribute your assets. And the law says that it goes to your children. And if you don't have children, it goes to your parents. If you don't have parents alive, then it goes to your brothers and sisters. If you don't have brothers and sisters alive, then it goes to your nieces and nephews. And it continues down to your closest relative at that time. If we can't find any close relatives, then the estate gets your money. And that is why we want to avoid probate, is because it's very expensive. As I mentioned earlier, the statutory fees are based on a percentage of the estate value, which says that the first 100,000, the lawyers and your administrator get 4%, and then the next 100,000 goes 3%. The next 800,000 is 2% paid to the executors and the attorneys, and then 1% of the next 9 million. So you can see, if you have any type of real estate, especially in California, that the fees add up very quickly. And it's not uncommon to have statutory fees in excess of 50, 60,000 or more. Whereas in a trust, that entire process is completely avoided, and everything is handled privately in an informal manner, where assets are easily accessed by simply showing a death certificate or a letter from your doctor declaring you incapacitated. And then the people that you've selected are able to step into your shoes and access your money, pay your bills, and ultimately distribute your assets according to your instructions. And they have to do that in a fiduciary manner. That means they have a legal obligation to follow the procedures set up by law. And what the law says is that they have to be super honest and keep detailed accounting, and they have to avoid conflicts of interest, and they have to be prudent. And no matter what they do, everything has to be calculated for the best interest of the beneficiaries, which the beneficiaries are the person setting up the trust during their life, and then ultimately, the beneficiaries are who are receiving the assets after the person's life. So it makes things much easier to have a trust versus going through probate.
Well, Cody, what happens during the probate process that most families aren't prepared for?
Well, great question. What people don't realize is that probate is a very tedious process, and things have to be done specifically and precisely the way the court wants it. So it's a very formal procedural process, and often people are surprised by the volume of paperwork involved and the court oversight. And so what happens is that no one in the real world wants to get in trouble. So that means they're not going to give access to anyone, even if they're your wife or your spouse or your children, because that third party, the bank or the investment company or the real estate agency, they don't know what you would want. And so they're not going to go out on a limb and just give access to your assets just because it's your spouse or your children, and then later be exposed to possible lawsuits. So that means that they will require someone to go to court and get legally authorized with permission to access your assets, right? And so during that time of obtaining the court order or the letters of administration, letters of testamentary, depending on whether you have a will or not, everything gets frozen and no one can access anything. So your bills can't get paid, insurance can't get renewed, and it becomes very stressful for your loved ones. So then probate is required, and that's where the headache and the anxiety and the grief kicks in, because now you have to file a bunch of paperwork and you have to wait your turn. And as we know, the court system is congested. So from the time you file the actual petition to be approved until the actual first hearing is 45 days. And until that time, no one can do anything. So it's a long 45 days. And then you have to file a newspaper ad. You have to send out notice. You have to find your local, your closest relatives if they're not available. And it becomes a ton of work for people which are grieving the loss of a loved one. So that's why we really emphasize why it's important to have a living trust, because all that can be easily avoided by simply establishing an estate plan with a living trust and a durable power of attorney and a healthcare directive, an assignment of personal property, instructions in event of dementia, instructions for final disposition, so that no matter what may occur during the process of a person's life. They will have the right document to avoid these types of hassles and legal expenses.
Well, how does your experience administering messy estates change the way that you draft avoidance documents for new clients?
That's a really good question, Shamika. So that's our advantage. That's one of our biggest advantages is that many other attorneys will say that they will create an estate plan for you. But we've seen so many bad estate plans from other attorneys that don't really understand how it works because it's not what they do day in, day out like we do. And so they believe it's just a matter of putting together some documents and sending you on your way. But because we see the problems that arise during trust administration and we see why people end up in probate court, that when we create these documents, we know what it takes to make sure they actually work because we see how banks respond when someone passes away and the process that's required to obtain access to bank accounts and investment accounts. And we see the problems that arise with escrow companies and why property can't be sold because it wasn't properly titled. And because we see these problems every day, we're constantly learning new problems and allowing us to become better estate planners. So, as we are speaking with each client and these common situations come up, we're able to give them real world answers and draft the documents in a way that will avoid these problems.
Well, since probate is such a public process, how do you protect high profile North Bay families from predatory scams that target published heirship information?
Well, that that entails avoiding probate. Now, probate is a public process. So that means
Hmm.
anyone can come into the court system and pull up the files and know exactly what you own and where your property is located and who your relatives are. And it's a very miserable process that we want to avoid at all costs. So, to avoid that public exposure, is we ensure that the client's assets are properly titled in the name of their trust. And for high profile people, we can name the trust in a way that doesn't reveal their identity. So for celebrities, very affluent executives, there's ways that can place your assets into a trust that doesn't necessarily indicate who owns that trust. And we never put social security numbers, driver's license, or full account numbers into a trust because that's not necessary. Okay. And so by avoiding that sensitive information into these documents, it prevents fraudulent opportunities. If someone were to obtain access to your trust documents, they won't have any information that would allow them to fraud you or to, intrude into your privacy.
Well, how often should North Bay residents update their trust to account for the changing California laws like Prop 19?
Well, the good news is that this area law is pretty stable. It doesn't change too often, but we do have some occasional shakeups. And so what we recommend is coming back every year or so, or if there's any major life changes, new new births, new marriages, deaths in the family, and just reviewing your documents so that we can ensure that they are still consistent with your beliefs. And that's something that we offer to all our clients. Whenever they may like, we allow them to contact us and go through their documents and make sure that things are still consistent with what they want. And if not, a trust can always be changed. That's why they call it a living trust. It changes as life changes. You can amend it anytime you want, as long as you have mental capacity, of course, and you know what you're doing. But it is a good idea to take a look on a regular basis and make sure that it's still what you want and the people that you've selected as your backup people are still the people that you would want to access your bank accounts. And pay your bills and make your healthcare decisions. And now specifically with Prop 19, that changed the manner in where you can distribute assets to your children, but the property taxes will go up unless the property that you give to your child is your primary residence and that child moves in to the property and makes it their primary residence. Then the property taxes will stay the same as long as the child lives in that home as their primary residence. Other than that, the property taxes now will be reassessed. Whereas before, parents could give their children all the real estate and the property taxes would remain the same, regardless of whether it's your primary residence or not. So what we do is we have certain language that we can include in someone's trust that will allow a child to continue to inherit that property tax basis. And if you're giving taxes, if you're giving real estate to more than one child, it's important to realize that even though one of them may move in, if both of them inherited the property, then only their portion will remain the same. In other words, the other child's share of that home will be reassessed, and only the child that moves in will be able to keep their portion the same. And so there's certain tactics that can be included into a person's estate plan that will allow that child to preserve 100% of the property tax basis. And we explain that to each client depending on their circumstances so that when the time comes, their children will benefit from the Prop 19, if possible.
Well, thank you, Cody. This has been such an informative episode. I've learned a lot.
Great. I'm glad to hear it. Yeah, my clients do say the same thing oftentimes.
Well, thank you for joining us for the Trust and Estate Clarity with Dada Law Office with Attorney Codi Dada. Please take a moment to subscribe, like, and share this episode with someone who needs to hear it. For more resources or to start your own plan today, visit NovatoLawyers.com and DadaLaw.com. Thank you for tuning in, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.